Supreme Court has handed down a massive 9-0 unanimous ruling.
Is setting a bar not just for Anaconda, not just for Montana, but for the whole country.
In a single instant, the highest judicial authority in the nation struck a hammer blow that didn't just bend a century of firearms regulation, it completely demolished it. 19 state capitals were instantly thrown into chaos. Legislative floors went dead silent. Legal strategies dissolved in seconds, and policy experts scrambled to make sense of a reality nobody anticipated. In an institution notorious for fracturing down the middle on every major constitutional debate, something unprecedented just happened. 9 justices, 1 direction. Absolute unanimity on the central question. With that single decisive ruling, mandatory training courses, expensive licensing fees, multi-week waiting periods, and broad public carry bans were wiped clean off the legal landscape. The traditional regulatory framework didn't just crack, it collapsed entirely. Before we unpack the massive fallout of this decision, take a moment to consider what this means for your everyday life. With permitting hurdles and government-mandated delays stripped away, does this represent a vital restoration of fundamental personal liberty? Or does it mark the start of a deep policy shift that raises serious concerns? Take a second to share your genuine thoughts below. No political talking points, just your real gut reaction, because that exact divide is driving the national conversation right now. To truly grasp how seismic this shift is, we have to look back at the aftermath of the landmark decision in New York State Rifle and Pistol Association v. Bruin. For 2 full years following that case, the nation was trapped in a state of total legal limbo. Lower courts issued wildly conflicting rulings, state legislatures rushed to pass fresh restrictions before the ink could even dry on court orders striking down the old ones. Responsible gun owners would go to bed knowing their actions were completely legal. They'd only wake up the next morning facing a regulatory nightmare of brand new local prohibitions. Bruin established a brand new constitutional benchmark, but without clear direct guidance on how lower courts should enforce it, the entire judicial machinery was grinding to a halt. That period of uncertainty is officially over. This brand new unanimous decision accomplished what Bruin only signaled from afar. It explicitly applied the legal standard known as strict scrutiny to the Second Amendment. In constitutional law, strict scrutiny is the absolute pinnacle of legal protection. It is the exact same rigorous benchmark reserved for our most fundamental civil liberties: the right to speak freely, the right to vote, and the right to practice one's faith without government interference. When a court applies strict scrutiny, it stops asking whether a state legislature had a reasonable or well-meaning idea. Instead, it demands ironclad proof that a contested law is strictly necessary to achieve a compelling government interest. And it must accomplish that goal using the most narrow, least restrictive means humanly possible. If a law fails to meet every single one of those demanding criteria, it is struck down as unconstitutional, period. For decades, the legal system relied on a far weaker framework called intermediate scrutiny. Under that old standard, as long as officials could point to a general public safety objective, courts would regularly uphold a steady stream of local restrictions. Over time, that approach effectively downgraded a constitutional right into a secondary privilege, a footnote on paper that could be buried under endless layers of bureaucratic red tape. That intermediate framework has now been discarded entirely. The court buried it 9-0, and the immediate fallout across state capitals is staggering. 5 massive categories of long-standing restrictions are collapsing all at once. This is sparking genuine panic in regulatory agencies across states like California, New York, New Jersey, and Illinois. An applicant could pass every single background check, clear every background screening, and present an utterly flawless record. Yet a single administrative official could still deny their application simply by deciding the applicant hadn't proven a special need to carry. While earlier rulings took aim at that concept, several states responded by creating new administrative hurdles, higher costs, and complex local exceptions. This new 9-0 ruling slams the door shut on those workarounds. It establishes without a shadow of a doubt that subjective government discretion has zero place in the exercise of a constitutional right. If an individual isn't legally prohibited from firearm ownership, local authorities can no longer manufacture arbitrary administrative hurdles to keep them defenseless. The second category facing immediate dismantling involves mandatory pre-carry training requirements. Here, the court's nuanced reasoning is critical. The justices didn't declare training to be useless or harmful. In fact, they explicitly acknowledged its practical value. However, they drew a hard, uncompromising line against administrative abuse. Government agencies cannot transform training mandates into high-barrier gatekeeping tools that economically price ordinary people out of their rights. If a jurisdiction requires a mandatory course that costs hundreds of dollars, is offered only twice a year, and takes place hours away from an applicant's home, it isn't a safety measure. It functions as a modern-day poll tax on a constitutional right. Those prohibitive structures are now legally dead. The third pillar to collapse is the traditional mandatory waiting period. The original concept behind waiting periods was the cooling off theory, the idea that a mandatory delay of 3 to 10 days between purchase and possession could stop impulsive acts driven by sudden emotion. While that concept held strong surface appeal for decades, the court ruled unanimously that delaying the physical delivery of a lawfully purchased item to an eligible citizen imposes a burden that states cannot justify under the historical standard. The fourth category undergoing total revision is the fee structure. The era of stackable fees, $200 application charges, $150 processing administrative fees, and secondary processing costs that collectively made exercising a right financially impossible for low-income citizens, is officially over. The justices ruled that any permit-related administrative fees must be purely nominal. If the overall cost creates a real financial barrier for an ordinary working person, that pricing scale fails constitutional muster. The fifth and final major pillar involves the broad expansion of sensitive places. Right after the Bruin ruling, several state legislatures attempted a major legal workaround by designating almost every public area as an off-limit zone. This included public sidewalks, transit networks, municipal parks, parking facilities, and local retail stores. The clear practical effect was that even if a citizen possessed a valid permit, they couldn't actually step outside their front door without violating the law. The court examined that broad strategy against historical precedent and rejected it entirely. Historically sensitive locations were extraordinarily narrow and specific, places like courthouses, legislative chambers, and polling places, not the everyday geography of an entire city. To see how these abstract legal shifts hit the real world, consider what happens on the ground. Think about a single mother working late shifts, relying on late-night public transportation to commute home through high-crime corridors. Up until now, navigating a maze of sensitive place prohibitions made carrying a personal safety device virtually impossible without risking a felony conviction. Overnight, those sweeping local restrictions have become practically unenforceable. At the same time, consider the position of a rural patrol officer stopping a vehicle for a routine traffic infraction. The driver presents a carry permit issued by another jurisdiction whose training requirements don't match local state standards. Under this new legal reality that out-of-state document commands full constitutional respect, it leaves the officer with zero subjective authority to challenge its validity on the spot. This is the new terrain of national carry, restoring personal access on one hand, while introducing complex operational questions for local enforcement on the other. To understand how the court built the foundation for this explosive move, we have to look back at a critical decision from 2024, United States v. Rahimi. On the surface, Rahimi was a high-profile domestic violence case where the court actually upheld a federal firearm restriction for individuals under active restraining orders. You might naturally wonder how a case upholding a safety restriction became the launching pad for demolishing permitting systems nationwide. The answer lies in how the legal tests were redefined. In Rahimi, the justices did something far more consequential than just issuing a single verdict. They clarified how lower courts must apply the historic analog test. Following Bruin, lower courts were wrongly assuming that any modern safety law required an exact historical twin, a law from the late 1700s that matched modern regulations almost word for word. That rigid standard caused chaos in lower courts. The Supreme Court corrected that misunderstanding in Rahimi, clarifying that states only need to show a historical analog, a founding-era principle with a similar broad purpose, not an identical twin. However, in this latest ruling, the court took that exact same historical test and turned it directly against state licensing systems. State attorneys attempted to argue that 18th century surety laws, which required specific individuals to post cash bonds for good behavior, were historically analogous to modern permitting fees. The Supreme Court soundly rejected that comparison. Why? Because founding-era surety laws targeted specific individuals who had already been identified as dangerous. Modern permit fees, on the other hand, systematically penalize every ordinary citizen before they can exercise a right. State legal teams also argued that early American militia training mandates were historical precedents for modern mandatory carry courses. The court rejected that argument as well. It pointed out that historical militia duty was a universal civic obligation for community defense, whereas modern carry mandates are administrative obstacles placed in front of individual civilians. As established in the landmark District of Columbia v. Heller ruling, the right to personal defense belongs directly to the individual, entirely separate from militia service. The downstream impact on national carry reciprocity is massive. For years, lawmakers have debated the National Constitutional Concealed Carry Reciprocity Act, a federal proposal that would require every state to recognize valid permits issued by any other state. Restrictive jurisdictions fought that concept with everything they had, but this unanimous ruling flips that entire legal battlefield on its head. If individual states are stripped of their ability to impose high fees, subjective checks, or mandatory multi-day courses on their own residents, the legal argument for refusing to honor out-of-state permits effectively collapses. The core principle that a fundamental constitutional right doesn't end at a state border is now firmly locked into Supreme Court precedent. Make no mistake though, this legal battle is far from over. States favoring strict regulation aren't backing down. They are rapidly shifting their tactics. High-ranking legal officials in states like Hawaii and Maryland have already reviewed the ruling and recognized that their old playbook is obsolete. So, where is the battle heading next? Watch the upcoming legislative sessions in tightly regulated states. The next major front will focus heavily on ammunition restrictions. Expect aggressive proposals targeting micro-stamping requirements designed to make standard ammunition dramatically more expensive or legally complex to purchase. Watch for new mandatory liability insurance bills, framed not as permit conditions, but as general commercial safety regulations. The constitutional debate over what constitutes a standard, legal arm is moving into unmapped territory. It is also vital to look closely at the internal debates within the court itself. Even though the core decision was 9-0, 3 separate concurring opinions were filed, and they contain sharp warnings that deserve serious attention. The true long-term impact won't be decided by media headlines, but by how state legislatures, lower courts, and ordinary citizens navigate this brand new legal reality. That's it for today, folks. See you in the next video.